as more and more states open for business, what is your liability to your clients, to guest attendees at the event, and your employees with regard to COVID-19? All that today on the podcast.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome back to the podcast. My name is Rob. Thank you for joining us. We have a fantastic information-filled episode for you today. We are going to have attorney Sara Tucker on, and we're going to talk about all things related to your potential liability as a business owner with regard to COVID-19 reopening, to your clients, to the potential guests at an event, and your employees. What all of this means in the new world of COVID-19. What's it mean to be negligent in the world of COVID-19 with your wedding business? Before we get into that, please, if you are enjoying the content of these episodes, like and subscribe wherever you get your podcasts. It really does help us out. And if you're watching this on YouTube, please subscribe. Please leave a comment. If you have suggestions for content, if you got questions, if you got things that you want to know about, then please let me know by commenting below in the comment section. So as I mentioned, today we're going to be talking about all things related to liability with regard to COVID-19 and opening up your business and having events in the world of COVID-19, but we don't do that alone. I have a former classmate of mine. We both graduated from Georgia State College of Law. I won't tell you what year, but she is a fantastic attorney. Her name is Sara Tucker. She is a phenomenal trial attorney. She is with the firm of Womble. It's I don't know. As I record this, it's a Monday, but actually it's a Tuesday, so I don't know why I said that. It's almost like a Monday, but it's in fact Tuesday as I record this. But she's with the law firm of Womble Bond Dickinson. Her name is Sara Tucker. She concentrates her practice on complex products liability litigation with a focus on pharmaceutical and medical device litigation. As a veteran trial lawyer, Sara has experience defending clients in high-stakes mass tort and multi-district cases in federal and state courts. She also has experience in consolidated state court litigation, consumer class actions, and medical malpractice. And what that means is she is a badass trial attorney. And we are very happy to have her on the show this week. All right, Sara, welcome to the show.
Hi, thanks for having me. I'm glad to be here.
Awesome. So, Sara, I won't bore you. I read your bio, so now everybody knows that we graduated together. So we're not allowed to tell stories about one another. We just stick to the subject matter of the show.
What? I didn't get that waiver.
So a couple of episodes back, I talked about a wedding professional's liability for if they negligently gave somebody coronavirus, and whether or not through the contract with the client, if that wedding professional could have the client waive liability for coronavirus. But I wanted to actually dig deeper into the concept of negligence and a business owner and wedding professional operating in now these phased rollouts, and what kind of liability issues there are with regard to that and doing an event. So can you just kind of like give us a 40,000 foot view of a wedding videographer, a wedding florist, or whoever going and doing an event, and what their possible risk is with regard to being sued for coronavirus, if that makes sense?
Sure, yeah. And so I kind of think about it in several different categories. And so one of them would be what you've addressed already, which is what happens if one of your clients gets sick, right? And they say that you gave it to them. So that's one area of liability that you could have is with a customer or a client. Another area of liability that you should be aware of is premises liability. So depending on, I know that some of the wedding industry professionals have venues that they rent out. So depending on who owns the premises where the event is taking place, there's going to be certain requirements for that landlord to take certain precautions like cleaning, sanitizing, keeping appropriate social distance between different people, not letting too many people into the space, those kinds of considerations. So depending on what your role is in the event, you'll need to think about that as well. And then some of the wedding professionals I'm aware of have employees also. So definitely look at how your business is structured, because there's also a potential for liability for one of your employees saying that you exposed them to the virus and perhaps you didn't give them the appropriate PPE or personal protective equipment like masks or gloves to wear, and they're saying that they contracted the virus and that you should be responsible for that.
Holy cow. I'm going to be straight up honest with you. I didn't even consider the premises liability component to this in
Yeah.
wedding venues. Wow. Okay.
Well, it's a lot more common in like an office setting, or if you're a manufacturer or something like that, right? Because you've got the landlord and then you have a bunch of people usually renting space out of an office building. So it comes down to sort of who's responsible for keeping that space clean, especially in the common areas like elevators and things like that. So I know at least for wedding planners, some of you would have office space somewhere. So make sure that you do know if you have a physical location, or some people even work out of their house. So make sure that you know what the cleaning protocols are that are in place for wherever your physical office location is, because that's really important too, and something that needs to be clearly delineated in terms of who has the responsibility. Is it going to be like your landlord who owns the whole building? Or if it's your house, that's probably going to be you. So keep those things in mind.
Okay. So if you will, let's kind of unpack that then. So, if I understand correctly, if you're in a location that's on a premises, like you actually have a physical location, let's just take our homes out of it, because most of our people operate out of a space.
Mm-hmm.
Or if you're a venue and you own the space. So I guess if I understand correctly, one of the best things that you can do is first have a written policies and procedures. Is that right? And if so, like what does that mean? What does that entail?
Yeah, so I like to think about limiting liability for COVID in three big buckets. So the first one I would talk about is plan. So make sure that you really sit down and you plan out what your strategy is going to be for when you go back to that physical location, and what you're going to do to mitigate the risk and to follow all of the guidelines and information that are out there. And it's really confusing right now. There's different guidelines in almost every state. So you need to figure out what the state government wants you to do. You need to figure out what the local government wants you to do. You need to figure out what the CDC is saying, what OSHA is saying, and then synthesize all of those rules. So you got to figure out what's going on and how that applies to your particular business. So that's part of the planning phase in analyzing all of those different rules. The next phase would be communicating to your employees or communicating to your customers what your plan is. A lot of this is a huge change for people from the way they were doing business previously. So I encourage everyone to over communicate with their employees and their customers so that everyone's really clear on who's doing what and what is required of them. And then the last part would be documenting. So in that planning phase, you came up with different policies and procedures for how things are going to look in this new space. Make sure that you take the time to write those things down. And if you have a landlord, like we were talking about before, make sure that it's clearly delineated somewhere in writing who's responsible for the cleaning protocols. And even if it is the landlord, you want to make sure you're aware of those cleaning protocols, because I don't think it's going to be reasonable. It's not going to be considered reasonable for someone to delegate all of that authority to a landlord. So make sure that you have at least a basic understanding of what's going on, so that if your employees or your customers ask you, hey, how are you keeping us safe? How are you keeping things clean here? You have a good idea.
That's an excellent synopsis. Let me step back and let me go higher up for the listener who might be being scratching their head and be like, who cares? Like, what is reasonable? What does all this mean? And I want to reiterate that just because someone gets COVID-19 at an event, and even just because somebody gets COVID-19 and you gave it to them, doesn't necessarily mean that you are liable under the typical laws of negligence. And so this is what Sara is talking about in terms of, typically, if you are synthesizing the rules of your local, state, federal government that's in the CDC, putting those into a particular policy, finding out what the policies are of the landlord, finding out what the policies are of the venue, and then implementing them, then 9 times out of 10, um, that's going to be considered reasonable and non-negligent behavior. And if you've acted in a reasonable way, such that, you know, I mean, what else can you do, a reasonable person do, and they still contracted it, then you're probably not going to be liable for it. So that's why we're talking about these things, because I think sometimes when people talk to me, Sara, they're saying, well, I mean, I don't want people to get COVID-19. That's not what it is. It's you want people not to get COVID-19, um, I guess, after you've done, you know, the reasonable amount of work to prevent them from getting it. Does that make sense?
Absolutely, yeah. And that's sort of the whole deal with negligence, right? Claims for negligence all come down to reasonableness, and it's a really fact-specific inquiry, and it depends on your specific case. So there's not a lot of across-the-board answers that can be given. But if you think about going through this whole process, analyzing each thing you're doing, and documenting it so that if someone came back later and said, how come you did that? Was that something that other people were doing? Was that something that you would expect another person that was in a similar situation to do? Those are the types of questions that you're going to want to be able to answer. If you can answer them, I think, like Rob's saying, you're not going to have as much liability exposure because you're going to be acting in a way that most people would consider reasonable.
That's exactly right. So, okay, so we don't have to get super wonky in depth on this, but what are some possible recommendations for somebody in terms of, we talked about synthesizing the rules of, like, you know, should they go to the CDC and kind of abide by them? Should we, you know, the governor, you know, of your state, whatever their rules are, how do we know where to go and do that? Is that something that somebody can a layperson do that? And if so, what's the way to do that?
Yeah, I think it just depends on how comfortable you are with reading all of that kind of information. But yes, I think that a layperson can do it. I would say make sure you're looking at authoritative sources, meaning, you know, probably not a news outlet, but looking more at the CDC or other government bodies and their recommendations, something that's slightly more neutral. So the CDC is a great place to start. It's going to have a lot of different guidelines and recommendations for businesses to implement. So start there, see what they say. For example, CDC currently has a recommendation right now that the general public wear face masks. So I would say if CDC is saying everyone should wear face masks, that should be something that you implement. And whether or not, if you have employees, you're going to provide that face mask to them or not is up to you. I would recommend doing that because it's fairly low cost. And if you're requiring your employees to do something, it's helpful if you give them an option at least that you're providing in case they can't get their hands on one. So sources like that are good to look at. And yeah, I think a Google search is, you know, a good place to start. Look at the CDC. If you're in Georgia, look at Governor Kemp's executive order that came out. And then I would also encourage people, you know, the wedding industry is fairly specific. So see what other people in the industry are doing, because that's really going to be your focus group of, you know, is my behavior reasonable? So if everyone that has a venue in across the country is acting at, you know, 25% capacity so that they can preserve social distancing, even if that's not a requirement in your locality, I would encourage you to sort of use what the industry is doing at the time, as opposed to just doing what's, you know, legally required.
That's an excellent point, because if for some reason, and we can talk about this a little bit later, because I have my own opinions about what the what the results of these with these cases will be, but at a trial for a negligence claim based on COVID-19, the plaintiff in the case, if you're a defendant, if you're the wedding professional and defendant, the plaintiff's going to say, well, this is what everybody was doing, and you weren't doing any of those things. And that's kind of what we're getting to. And if everybody in your local community was wearing PPE, or if everybody in your local community was limiting, to 25% of capacity so that they could maximize personal space, then that what we're uncovering is that's the objective reasonable behavior of somebody. And because you as a wedding professional have fallen below that line, then you might be liable for the COVID-19. But um, I want to kind of touch on this, Sara, that the idea of what is reasonable in California might be different than what's reasonable in South Georgia. Can you kind of talk to that a little bit?
Yeah, that's true. I mean, I think you want to look at what the local jurisdiction is doing. And as everyone knows, right now across the country, we have a whole patchwork of different rules and regulations. So hopefully for most of you, you're just operating in one jurisdiction, unless you're a super large business. That gets complicated if you have more than one jurisdiction to worry about. But if you're only operating within one state, then look at what the state executive order is having you do. But keep in mind that that state executive order might be completely different in Georgia than it is in California. So while you might not be legally required in Georgia to do the things that you have to do in California or vice versa, I think it is wise to stay abreast of, like I said, what the industry is doing across the country, because the reasonableness standard is fairly fuzzy. So it's not something that is a bright line rule. It's not like here's what the statute says and that's what we're going to apply. It's going to end up being that the plaintiff's attorney could introduce evidence of what other wedding professionals in your industry that are similarly situated are doing. So if the wedding professionals in California are giving PPE to all of their employees, but they're not doing that in Georgia because it's not required, they could still potentially introduce evidence that there are some professionals that are providing that, and then that could be used against you. So although the standards might technically be different, I would still encourage to look across the board and sort of treat things more as a floor and not as a ceiling.
That's great advice, Sara. Can we, okay, so we talked about kind of to the public and their in liability with regards to how you behave, and your liability with regard to attendees and clients.
Mm-hmm.
You mentioned that one of the buckets of liability being employees. Can you kind of unpack that a little bit? What does that mean?
Yeah, so a lot of people have been asking whether or not workers' compensation insurance will cover claims by their employees that they got sick at their workplaces. And the answer to that is it depends, which is an attorney's favorite answer to give to anything. But workers' compensation insurance and the laws surrounding that differ by state. So first you have to figure out what the laws are in your state. And then some states like South Carolina have really favorable to the business workers' compensation laws, which pretty much say everything falls into workers' comp. But in most other states, you're going to have some exceptions, at least for things like gross negligence. So whether or not a COVID claim would be covered under workers' compensation insurance is going to be a state-specific question, and one that isn't going to necessarily be easy to answer. Historically, workers' compensation claims haven't covered things like an employee getting the flu at work. But that being said, sometimes other illnesses have been covered when they have been shown to be acquired at the workplace. So right now, we don't really know how that's going to shake out. There's also legislation that's been proposed at the federal level to make workers' compensation claims cover all sorts of COVID allegations, but none of that has passed yet. So that's sort of another thing to keep an eye on in terms of your exposure. But just generally speaking, an employee could sue you for contracting COVID at your workplace, or in this case, if you were working an event and you had an employee that worked for you that alleged that you didn't take sufficient precautions to protect them from acquiring the virus at the event, I could see that being another area of potential liability.
Interesting. So can you kind of talk about what's the policy rationale behind why, if we can show by preponderance of the evidence that you contracted COVID-19 as an employee due to the negligence of the employer, why would that not be a workers' comp claim? I don't understand what the rationale is behind
So usually workers' comp claims, and it depends on the language of the statute, but they cover injuries that happen at work. So it doesn't always cover illnesses specifically. So if you can make the claim that the COVID-19 virus acquisition is an injury, then you might be able to get that covered, but that's not always the case. And typically, in these types of cases, it would be fairly easy for a plaintiff's attorney that's savvy to allege gross negligence. You know, they had a protocol and they didn't follow it for cleaning, or, you know, they were grossly negligent in failing to provide PPE to their employees, and so they got sick. So those are all potential areas of exposure. Now, that being said, it sounds very doom and gloom. I think that actual risk of an employee suing you for acquiring COVID is fairly low. We have seen some lawsuits across the country already against employers for that. For example, there was one lawsuit against Walmart for an employee that had acquired COVID while they were at the workplace. So that's working through the system right now. But I think realistically, between workman's comp and just employees not frequently suing their employers, combined with the fact that it's going to be incredibly challenging to prove causation in cases like that, because how are you going to show that you actually got the disease when you were at work, as opposed to going to the grocery store or from your kids or some other route? So
that?
I don't think the exposure is super high.
Yeah, and that was actually what I wanted to talk to you about next. Was I talked about this on my other podcast episode about liability waivers, the causation issue,
Mm-hmm.
and I mean this is coming from a plaintiff's lawyer. Okay, so like I mean, I just don't understand. Like even if I broke out a policy and procedure that you had that you were ignoring, and
Mm-hmm.
you were grossly negligent. Okay, as the wedding professional, how in the world am I going to show? Like you would have to get the best infectious disease doctor expert to show that I am eliminating every other, like there would have to be nobody else at the event that has COVID except for you. You know what I mean? Like,
Well, I mean, as you know, the standard's just preponderance of the evidence, which just means more likely than not. So all you have to really show is that it's more likely that the person contracted the illness at your workplace. And if they had evidence like, we never went anywhere other than work, you know, we were quarantined at home and the only place that I possibly could have been exposed was work.
well, yeah,
You
I
know,
guess what I'm saying is that is if you did it, if you got it at the event, you would have to test all 100, people. Like what, like right? Like I guess. Well, then I guess if you weren't doing what you're supposed to do as an employer, I guess. Okay,
um,
I see what you're saying. Yeah.
well, or if you saw that 100 people out of 150 at that event came down with COVID, you probably have a pretty good indication that it's
Yeah,
something that
you're
has
right.
to happen there, right?
Exactly. Okay, I see what you're saying. I was being dumb. Okay, you're right. You're right. So, but yeah, my deal with that is that causation would still be pretty hard to prove in these cases.
For sure.
Well, Sarah, is there anything else, like any other kind of actionable items for any wedding business owners out there? We want them to check your local and state websites for information, the CDC, try to get something written and then enforce them, and talk to other industry professionals in your community to see what everybody else is doing and then implement that. Is there anything else on top of that that people can be doing to kind of lower their risk of liability?
Yeah, I'd just say a brief note about waivers. I know that you've already talked about those a little bit. Because you are in a client-facing business, a consumer-facing business, you can consider having liability waivers given to people that you interact with, and sometimes those will be found to be enforceable. For instance, hairdressers and nail salons and things like that. I've been seeing a lot of waivers for customers that come in that are interacting so that they know that they are assuming the risk of being in that space. And especially in contexts where you can't appropriately socially distance. I mean, there's only so far away your hairdresser can be from you. So, I mean, I think things like that you can think about. But in terms of employee waivers, so asking your employees to fill out a waiver to prevent you from getting sued by them, that's not something that you as an employer can do. They're not considered enforceable as a matter of public policy in the courts. So I wouldn't go down that route. And
What
then,
I'm
yeah,
sorry.
go ahead.
I was going to say, Sarah, what about the idea? And again, I talked about this in the other episode, and I said it can vary by state, but I don't know. But the idea of posting a exculpatory clause at the event itself, so you have to like walk by and touch it, like the football players at Notre Dame before you walk into the event. Do you have an idea about like the likelihood of enforceability of something like that? By virtue of being at the event, you are agreeing to waive liability for COVID-19.
Yeah, I mean, I don't think it's a bad idea, right? It can't hurt to have that. Now, whether or not that's going to exculpate you completely from liability, it's not going to prevent someone from filing a lawsuit, that's for sure.
Yeah, nothing ever on that front.
You should know that, Rob.
Yes, I do. That makes sense. I mean, like I said, I think you're right about the employee situation, but with regard to the clients, again, because we have listeners in multiple states, your state, it's highly dependent on what you can do, depending on what state you're in, what jurisdiction you're in, and the degree to which you are allowed to free yourself of liability from negligence or gross negligent behavior. Some states mark that a line in the sand that won't let you do one or the other. Some states won't let you do any of it. So you have to check with an attorney in your area. But.
Yeah, and I mean, I think it sort of goes back to the communication prong of things, right? Think about what you're telling your clients, who you're working with at these venues, right? It could be in your best interest to send and have something in an email or the contract with them that says, hey, this is what we're doing in terms of mitigating the risks of COVID-19. We're only allowing X percentage of guests within this venue in order to preserve the social distance and have plenty of air circulation. We are using a, ionic air filter that's going to help improve the air quality, or we're having the event outside so that there's less risk with that. We're not going to have a buffet. We're going to clean all the high touch surfaces, more frequently. We'll have a special person that's just doing cleaning. Make sure that you delineate exactly what you're doing. That way, if someone comes back and sues you later, you can say, listen, here's what we talked about before. It's in writing. I said I was going to do X, Y, and Z, and you said, okay, I'm fine with that. And I'm going to assume the risk here that if anything happens, I realize that you're just doing X, Y, and Z. So if I end up getting the virus or someone else gets the virus, they can't come back and say, hey, we didn't know you weren't doing, something else.
That's fantastic. That's also something I never kind of considered, is having it up front in your contract. These are the mitigation steps that we're taking. If you can't get on board with that, then jump the train. So that makes
right.
sense.
Like, I mean, I would even say consider getting your written policy that you're going to have on cleaning if it's your event space, or your PPE policy for your employees, what they're going to be wearing. Just attach those as addendums to your form contract that you usually have clients sign and say, I'm going to acknowledge that I received this protocol. You can have them sign it and date it. And that way, at least you have a piece of evidence that if something happens later is going to be beneficial to you.
Excellent. Well, Sarah, I think we've kind of beat this one to death. I know we can talk all day about it, but we're probably good in terms of the basics. So I really, really super duper appreciate you coming on the show. I know you're so busy and you're, trial for trial. So I appreciate you taking the time and talking to me and the audience.
Yeah, no worries. And if anyone has any follow-up questions, I'm happy to answer those offline, or my information is very easy to find. So feel free to email me or reach out by phone, and I'm happy to, have some one-off discussions with people if that would be helpful.
Fantastic. And I'll have your information in the show notes in case anybody is interested in talking to Sara.
Great. Well, thanks, Rob.
All right. Thank you, Sara. For me, to have somebody like Sara on is great because it is an example of what it is like to talk to someone who knows something so well that she can take these complex issues and break them down into bite-sized, understandable pieces of content, and not just content, but actionable items. So again, really appreciate Sara coming on the show and talking to us about these issues. If you liked the content of this particular episode, then please like and subscribe. If you have suggestions for things that you want to hear, let us know. And if you have questions for Sara, her information will be in the show notes below. And with that, thank you so much for watching. Thank you so much for listening. We'll see you next time.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.